Hi, I am Anne Elizabeth Hussein, an attorney at law. This is the third part of the presentation, or more the discussion of wills and estates. We are looking today at estate duty. Estate duty is more of a burden, and many persons are asking, including myself, what is the purpose of estate duty? Why does the government has to benefit from taxes when residents, persons are residing in homes, family homes, and inherited property has to pay a tax to the government simply because they want to regularize their family inheritance. When we are talking about commercial property, I could understand paying a tax burden. If you would like to hear more content, please remember to like, subscribe, and share my YouTube channel. Hit the bell icon for notification. When I upload any new video, you will be notified. Okay. Estate duty. This is what estate duty is all about. You have to attend the office of your attorney at law. You have to attend the Guyana Revenue Authority. You have to attend the wills and probate registry. When you want to make an application to be the executor or the administrator for deceased property, you will have to pay estate duty. You will have to attend the office of an attorney to prepare the oath. And then you will take it with a set of forms. Either you would get it from the attorney's office or directly from the Guyana Revenue Authority. And then you will be issued, after you pay the sum calculated, the tax, the estate duty, a proper officer certificate. The proper officer certificate is attached to the application that a lawyer would have prepared to be lodged at the wills and probate registry. Okay. The forms at the Guyana Revenue Authority. You will have to fill up the estate of deceased persons declaration and inventory for the Commissioner of the Internal Revenue. That form actually mirrors the oath that you would have signed off on if you're the individual, or if you're the attorney at law. You would realize that the oath mirrors this form. So it is a replicated process. And the declarant has to sign it. That is the person applying to be who is the intended executor or the administrator for the deceased person's estate. And it also carries the description of the property there and the gross value of immovable property. The next form you will have to fill out is called the inventory of property subject to estate duty on the death of the deceased. You will have to fill out the deceased person's name. It has a listing of the shares. It has a listing of cash. You have to fill out the information. If there's any cash, there's a whole list of items there of immovable property. As well as you would have to give a calculation as to the total movable and the total immovable property. There is also a section that deals with the liabilities. For instance, the amount for expended on funeral expenses. But I am told that that doesn't count in calculating the estate duty. They look at the assets. And that form also has to be signed by the attorney at law and the intended executor or administrator. And at the back of the form, it has the calculation of the estate duty, but I would leave that blank. When I go into GRA, or when the client rather goes into GRA, the intended administrator executor goes into GRA, they will do the calculations. So this form repeats the first form, the information there, but it is more detailed. Then we have now the inventory of property. It is mirrored something called the statement of assets and liabilities, and that is what your attorney would have had prepared. So it is a replicating again that information. The other issue now, when you go into the Guyana Revenue Authority, they are asking the administrator, the executor, for their TIN certificate. That is a taxpayer registration number. And then they're asking for the deceased person's TIN number. And if you do not have the deceased person's TIN number, or you do not have a TIN number, you have to fill out their form. The form is available online, and you would have to attach necessary documents there. The GRA form has a lot of supporting documents that are required, which are, in my opinion, all unnecessary. And they should, in my opinion, refer to the code and the application that is prepared by the attorney and the client. It is recommended that the client or the intended administrator executor just has to lodge it at the Guyana Revenue Authority and pay the amount of taxes, as opposed to having all these forms filled out by the Guyana Revenue Authority. It is repetitive work, it is unnecessary. And when I'm talking about the TIN for the deceased person, if they don't have it before, it is, in my opinion, illegal, because the fact is you're intermeddling with the estate. You can't intermeddle with the estate at the bank, you can't intermeddle with the estate anywhere else. It's always a problem, but you have to intermeddle with it to get a TIN number for a deceased person. I could understand when the administration is issued, you get the TIN number for the estate, but for all intents and purposes, for the ease of doing business and for the public, it is my firm opinion that the Guyana Revenue Authority needs to revamp all of these ridiculous forms and just use the statement of assets and liabilities and the application that is prepared by the attorney at law, because their business is only with the calculating of taxes. Because obviously there won't be any difference. There wouldn't be any difference between the statement of liabilities that the attorney prepare, and they wouldn't, you know, in filling out the form that are available to the Guyana Revenue Authority. The supporting documents is a whole lot of documents, and some persons are even asked to get the birth certificate for the parents that would have died like a long time ago, back in 70s and the 60s, and I find it just absolutely ridiculous for in order to obtain a TIN number as a keeper, to just to pay your estate duties. I don't really understand the relationship between your TIN number and trying to regulate your property. No, you know, it shouldn't be deterred by a month, 2 months, but I have to go to GPO building to get a death certificate, a birth certificate, a whole set of, you know, unnecessary things in order to satisfy the GRA to get a TIN number before you can actually obtain the rights to pay estate duty. Well, I'm told that all the documents that are submitted to the Guyana Revenue Authority should be on short paper, except their forms, which are ridiculously huge and wide, unnecessary again. I'm very critical of this because it's very upsetting that, you know, to regularize your property, there's so much encumbrances to just to pay taxes. The taxes alone defeats the whole purpose. The taxes alone adds to the length of time in obtaining letters of administration or probate. And then in order to fight off competing interests or alleged interests, you have to meet all these requirements by the Guyana Revenue Authority. Okay, when you have obtained when you've paid the taxes finally, you would be given a proper officer's certificate. That is that you pay the estate duty, and that is attached with the application. This is the application of the administrator or the executor of a deceased person estate. You have the oath that has to be prepared. The oath sets out the facts surrounding the death, surrounding relationship to the deceased, and certain requirements that are set. You have to provide the statement of assets and liabilities, right? So it will come from the will, or it would come from, if there is no will, the collection, well, rather the sum of what the intended executor or administrator believes to be the assets and liabilities of the deceased persons. But what I'm seeing is that it is mostly the assets and immovable asset is placed there. We need to also, as I recall in the video before, dealing with will making, shares are very important there. It's immovable property, but it requires administration to deal with in terms of transferring to a beneficiary. We have other supporting documents, and you would see the link below for other documents that are required in the application process. Like, for instance, the will, or if there's no will, consents, renunciation, those kind of documents, power of attorney, the proper officer certificate we talk about, and the affidavit of attesting witness. This affidavit is either prepared by the attorney, but I would send the client, if they're here in Guyana, to the registry, and the registry have a form that the witness would fill out and sign it up right there, and then they will do a certificate and attach it to your application. After all these documents are in good and order, checked by the registry staff, they allow you to pay a fee. And when you pay the fee, you get a stop to come back within 2 to 3 months to uplift the letters or administration or probate. I am seriously thinking that there needs to be amendments to the forms, or the abolishment thereof, rather, of the forms that are used by Guyana Revenue Authority, because it is repetitive in nature, and between the court and the registry, or the court registry and the GRA, you don't know which one is the chicken, you don't know which one is the egg, in terms of having the correct documents filed for administration. Because you have an oath prepared by the attorney's office and it is used at the GRA. Then when that is complete, that process is completed, the GRA have their own say, apparently the officers have their own say. And then when that is finished, you are going to, the oath may not match the oath that is actually submitted to the wills registry. And it should be the wills registry should have the control of the process, not the Guyana Revenue Authority. And that predicament is somewhat rhetorical and needs to be looked at. I am suggesting, most important, that there should be abolishment of estate duty, especially when you're dealing with transferring of family inheritance. The government, what are they doing to get such hefty sums? When we look at the average value of property on the market, it's around 50 million or so. And persons want to regularize their land, want to have the correct documents for their land, want to have title for the land, but the kickback is to find the monies to pay the lawyers, to pay this huge chunk of monies to estate duty. Or even if there is not a huge, if there's not property, the process of under 100,000 small estate, it is very much burdensome, especially with this pandemic that we find ourselves in. It is very burdensome with having to go to inquire and having to pay a test of $4,000 just to go inquire, just to go on back and forth. It's not economical. The estate duty, it is a huge chunk of money for no purpose. It really serves, and the GRA is just creating a lot of paperwork, and it does not even add up to the sum of money that an individual would have to pay just to regularize their property, just to have correct title, just to fend off trespassers. When we look at the legal fees, it's also a factor to prevent people from regularizing their properties. So all of these documents and forms are unnecessary at the end of the GRA part, and it can use some benefit from taking off the workload for attorneys and the costs involved for private individuals. And I just discussed the illegality or the illegality of estating. As again, if you like these videos, these discussions surrounding wills and probate, I would like you to leave your comment below. I like to hear about your experience, and maybe, who knows, as I'm saying, we look at what the law is, and maybe someone that has the responsibilities for these issues would try to make a difference for the benefit of the population. So again, I am Anne Hussein. Thank you for taking the time to listen. And please look at my other videos if you want further information. And I will leave the link below for other videos that are relevant here. So thank you.